Tonight, as I said for my intro, we are going to look at immigration, specifically the EU settlement scheme. I'm going to take my time to take viewers through the scheme and those who are eligible to make applications, including those who currently have their leave to remain, how they can ensure that they continue to meet the requirements through the path that leads to indefinite leave to remain. So I chosen tonight because we were all aware that there was going to be a deadline on the 30th of June 2021. But the good news is that this deadline was then extended indefinitely. And this was confirmed by the Home Secretary on the 16th of December 2021 that the deadline extension will subsist indefinitely. So which means that those who didn't have the opportunity to make applications, and I will soon look at those who are eligible to make these applications. Those people can still continue to make applications. So on the exactly next month would have been a year since this deadline extension has subsisted. So tonight is an opportunity for us to look at updates, look at how decisions are being made, and what records people have. When I say records, I mean those who want to choose the path of administrative review if their applications are refused, and those who want to choose the path of submitting appeal to the Immigration Tribunal. So tonight is your opportunity. And I'm sure that most of you may have family members who may have some of these applications pending, or some of you have been successful in those applications, have been quite widely been granted leave to remain. But you may not know the conditions therein that you need to abide by so that you can be able to get indefinite leave to remain after living on that route or on that path for 5 years. But also, there are those who are yet to make applications. And sadly, there are those who have also been refused. Some who perhaps may even have made re-application. Some have appeals pending. Some have administrative reviews pending. So tonight I'm going to more or less give an update of this scheme, and obviously continue to explain to people what they can do in order to ensure that they can be successful in those applications, especially those who are yet to make applications, since the deadline has now been extended indefinitely. So I want you to invite your friends and family members, because I'm going to invite my friends during my break to join this show. And if this is the first time you've joined us, as I always say, we do this program every Tuesday and every Thursday. On Tuesdays we do the English session, and then on Thursday we do the Chi session. Now it's also an opportunity for people to phone in when I open the phone lines to ask legal questions. I might not be able to provide counseling if your marriage is breaking down. I might not be able to prescribe medication for you if you are sick. But one thing for sure, I know the law. And tonight is your opportunity to have free legal advice. Advice that costs you nothing, but yet very, very, very good advice. So please invite your friends and family as I go for this commercial break. And then when I come back, I will take my time to gradually take viewers through my topic for tonight. Don't go away. Thank you for your patience. As I said, tonight I'm going to take my time to deal with those of you who have pending applications under the EU settlement scheme, those who are yet to make applications, and those, sadly, who have been refused and perhaps have made or submitted an appeal or administrative review of those decisions. So I want to take my time to gradually set the background for tonight's discussion. At the end of this program, I'm going to ensure that I give viewers opportunity to ask questions. And in fact, any legal question, as long as it's within my area of competence that I practice, then I'll obviously give you that free legal advice. So tonight, I'm looking at the EU settlement scheme. Now, to start with, before we left the EU, obviously, when the UK left the EU, all those who had residence cards and indefinite leave to remain under the EU regulations were asked to register under the scheme, and those who were new applicants were equally required to make applications under the scheme. So this is a scheme that has been there for many years now. And there was a deadline that was set for the 30th of June 2021. And owing to campaign against the deadline that most people wouldn't have been aware, and perhaps most people wouldn't have had the opportunity to register under the scheme because of literacy, technology, internet, those who perhaps may not even have access to internet, and various reasons. And for that reason, the deadline was extended. Then on the 16th of December 2021, the Home Secretary, Priti Patel, confirmed that this deadline has been extended indefinitely. So it means that people can still make applications under the scheme if they didn't make the application before. So more or less there is no longer any deadline, and we've still been making applications for clients. But let's look at first and foremost those who are eligible to make applications under the scheme, because this is something that normally comes up. On Monday, somebody called me, for example, asking a question about this issue. And in fact, he has even gone ahead and made the application and been refused. To start with, after the 31st of December 2020, when UK signed the withdrawal agreement, we officially left the European Union. And when we left the European Union from the 31st of December 2020, there was a significant change. And that significant change quite unfavorably affects extended family members. So whilst in the past there is what we call Regulation 8, which is extended family members, nieces, nephews, cousins, and all other extended family members who hitherto could make applications from the 31st of December 2020, when the withdrawal agreement was signed, they were cut off. So those extended family members were no longer eligible to make applications under the scheme. Sadly, people are still making applications as extended family members, and those applications automatically are being refused. For example, on Monday, I had a French national who called me that a cousin is here and he has made application and it's been refused. And I said, yes, because there is no locus in law. There is no grounds for those applications to be made anymore. So when you make those applications, they are automatically going to be refused. However, there is an opportunity for some family members to still make these applications. And these family members are the close family members, which previously was under what they call Regulation 7 of the 2016 of EE regulation. And these are spouses, children under 21, and children above 21 whose parents are able to show financial dependency. And I will take my time to explain this terminology. So, and of course, mother-in-laws, quite a good news, they can still make the applications. Parents, they can still make the applications. So I will say that those under the nuclear family, they are able to make these applications, except those extended family members. So if anybody is making an application and it doesn't fall within this family line, then automatically this application is going to be refused, sadly. So it means that there are say two categories of people who can broadly make these applications, which is those who are coming from abroad, who are spouses, those who are coming from abroad. And when I say spouses are, for example, relationships that have existed before December 2020. Again, a lot of people have had clients who have made application without being aware that any relationship formed after December 2020 is not eligible to make application under the scheme. And that application will be automatically refused. So you have people who have entered into marriage, for example, in January, February, March 2021. In fact, some even May 2021. With the intention, or who have made application under the scheme. And quite rightly, they have been refused. However, relationship formed before December 2020, those people are still eligible to make these applications under the scheme, especially in Ghana, where the customary registration law 1985 or amended 1991 allows registration to be optional. It means that those who form their relationship and so decide that they want to register it now, they will still be eligible to make those applications if their relationships were formed before December 2020. That notwithstanding, we have those who are also partners whose relationship were formed before December 2020, or those who are partners, they are equally eligible to make these applications. And this applies to those who are both making application for EU settlement scheme family permit, which is those who are making this application and be granted 6 months and come here, and after being here for within 90 days, making the application for their residence cards. But the point here is that even those who are partners, they are equally eligible to make these applications. And then around October, we have now had this amendment which allows, October 2021, which allows what they call joining family members. So it means that before this date, most of you who were refused because you could not show that you were here before December 2020. And I want people to take note of this. This amendment is so significant. This October, the reason being that in the past, when people have made applications, they have been refused on the grounds that they have not been able to demonstrate that they were here before December 2020 by showing proof of address. And they couldn't have been here as visitors. When I say visitor, which means that if you came here with entry clearance visa as somebody who is coming on a family visit, then before October 2021, you couldn't have, even if you were a spouse of an EU national, you could have made that application in country, because you'll be required to make an application for family permit in order to join the EU family member in the UK. But going forward, this category of people have now been allowed to make applications. Recently, a stranger walked to our office and he fits within this category of people. He came with a visit visa, and the relationship had been formed before December 2020, and he was quite confused. Obviously, as I said from the beginning, I might not be able to give counseling advice, but I can give you the law that will assist you. And quite rightly, we're able to advise him that he's eligible to make the application, notwithstanding that he is on a visit visa. So that is that particular amendment or change which is so significant. But the fact here is, I'm sure this is going to be somehow be tested in the tribunal. If joining family members are being allowed to make applications when they were not in the UK before December 2020, then perhaps those who for one reason or the other were living in the UK but for some reason cannot adduce evidence, cannot provide any evidence to show that they were here before December 20, perhaps quite arguably might make their case under that amendment. And this sounds a bit technical, but obviously I'm sure that is something that can be tested in the tribunal. But going forward, you can see that I have looked at those who are eligible to make these applications. I have looked at when one can make application from abroad, when one can make application whilst they are here under the scheme. I've also made abundantly clear that the deadline has been extended indefinitely, so it's like an open gate for everyone who is eligible to continue to make those applications, including grandchildren, grandparents, in-laws, mother-in-laws, and father-in-laws. But the most crucial question now is, if these favorable amendments have been made to the settlement scheme guidance or rules, why then are most applications being refused? And this particular area is quite important because people want to know why these applications are being refused. So to start with, I always say that when decisions are made and applicants are refused, it doesn't always mean that Home Office is right for refusing those applications. In fact, they can refuse applications for various reasons, some of which might be incorrect or might be out of administrative error. So the question is, those who have been unfortunate to have their applications refused, is there any remedy for them? Is there any recourse for them? Is there any further solution that they can consider to ensure that even if Home Office have decided to refuse the applications, is there anywhere else that they can take their case to and seek justice? This is what I'm going to take my time to explain, because this particular area is so significant. Because normally, when these applications have been refused, as I've said, some for very good reasons, some for reasons that are not genuine or are not right. And therefore, if the reasons are not correct, then people are entitled to seek redress, which means that people are entitled to make an appeal to the Immigration Tribunal or administrative review. But what I want people to understand here is that there are requirements which are set out for people to meet when these applications are submitted. And therefore, when people don't meet these requirements, the applications are going to be refused automatically. But there are those who also meet the requirements and then the applications are still refused. And from experience, and most of the cases that we have been dealing with, there seem to be three main reasons, especially for those of you from Ghana, that these applications are then refused. One is because of the fact that the law in Ghana allows registration of these marriages to be optional. It means that if relationships were formed before December 2020 or marriages by proxy took place before December 2020, they could still be registered today. However, most times there is misinterpretation of the Ghanaian law, and therefore some of these applications are incorrectly refused. That's one grounds. The second grounds is those who may not have evidence or proof that they were living in the United Kingdom before December 2020. And these proofs are varied. And when I was doing the 20-year rule, I said that the very documents that sometimes the Home Secretary wants people to show that they have lived here for 20 years is the same documents that the law forbid them from having it. In fact, these days, when people have exhausted their judicial remedies, for example, the applications have been refused and their appeal rights have been exhausted. Some of them, even their bank cards are being cancelled or their bank accounts are being closed. Some of their driving licenses are being revoked. And these are some of the documents that people will need to show as a proof of residence in the United Kingdom. So you can see the difficult conundrum that people face when they have to meet a requirement which is more or less insurmountable, or is so difficult to meet. However, when you are looking at the EU settlement scheme, they have actual evidence and they have alternative evidence when you look at the guidance. So the actual evidence will be something like your pay slips, bank statement, council tax, HMRC letters. But some of you may not have had this document quite rightly so, because you only became a family member to regularize your stay. So there are alternative evidence, such as if you have life insurance, such as if you purchase a product and you were issued an invoice. So if, for example, you registered with the NHS and you were sent out letters, so it means that there are other alternative evidence which are quite flexible for people to be able to prove or use to rely upon to show that they were here before December 2020. The absence of these documents may result in applications being refused. The last point, which is quite significant, is the issue of invitation for an interview. And quite rightly, these days, people enter into relationship. Sometimes because there is competition for people to form relationship, because there are more fishes in the sea. So you realize that sometimes people don't give out all the background to their potential spouses or their spouses. And sometimes when people are invited for these interviews, for example, if the parent, the spouse have had a child before, and he never informed the other one, and then during the interview he mentioned that he has a child, while the other one was not aware, and he was put to the same question, and he could not answer verbatim, which is to say that, yes, my spouse has a child from another relationship. Then it means our previous relationship. That it means that at that point there have been inconsistency in their account, or their stories are not matching. So that might be a grounds for alleging the famous or the notorious marriage of convenience or sham marriage. So these interviews are also grounds when people have attended them and have not been able to perform very well to convince the case workers that their relationship is genuine, sometimes result in these applications being refused. So these are three grounds that normally these applications are now being refused. But I always say that, and in fact, some people, even when documents are submitted, they are also alleged to be false, when in fact they may not be forged documents. But I'm going to deal with this quite very soon, when I'm looking at how the tribunal looks at these decisions. Because the moment you move from Home Office decision to the Immigration Tribunal, then you are looking at an independent judge who is unbiased and looking at the decision and the law. So, but before I do that, with regards to the interview, Home Office own guidance stipulates two things. One is that there can be adverse inference which means that they can come to a reasonable conclusion or suspicion that your relationship is not genuine if you fail to attend the interview. However, they must have a cause. They must have a reason. And this is the point. Because the guidance says that if one fails on 2 or 3 occasions, which they always do, to attend an interview upon invitation, then the application should not be refused. And this is must not. So it's a command. It must not be refused due to failure to attend the interview. So it indirectly means that failure to attend the interview, it is not legitimate grounds for refusing applications, because the guidance, which is I always come here to make sure that I don't speak fiction, because I give the facts. The guidance makes it clear that failure to attend an interview, it's not a grounds of refusal. It means that the caseworker is obliged, is supposed to say something beyond your failure to attend the interview in order to refuse that application. But most of these applications are being refused simply because people have failed to attend these interviews. So, having explained the 3 main grounds that these applications are now being refused, I now want to look at how the tribunal deals with cases when applications are made to the tribunal. Because when applications or when appeals are submitted to the immigration tribunal, we have moved from that territory where Home Office exercises its power to make decisions on applications. Whether those decisions are wrong or right, they may decide to refuse those applications. When it gets to the tribunal, we are looking at an independent judge who is fair-minded, is supposed to be fair-minded, I should say, and making decision on that very refusal before him, applying the relevant legal framework. So in this case, if for example, one has submitted application and it's been alleged, and I'm going to deal with these 2 areas because they are quite common in most of these refusal letters. But before I do that, I want to take opportunity to acknowledge viewers, because it's always important that I acknowledge viewers who I have Fred Asari, our sponsor, the Warner, and I have Mabel Opon Mensa. It's a good evening. I have Desmond Bernie watching live. Thanks, Goya, for the good job. I have Carol Brown. Carol Brown is a new viewer on the platform. Welcome. I have the famous Sophia Song who is watching tonight, and I have Dora Fimpong. So please, if you are on the platform tonight, you can just give a signal and I'll acknowledge you, because I appreciate all of you who join us for us to have this interactive discussion. So at this point, I don't want people to lose hope when their applications are refused. It was in this very studio that somebody phoned in to give a testimony that it was alleged that he has submitted for documents and his application was refused. And he came to City Law Solicitors and we took the matter to the tribunal and won the case on his behalf on the basis of what I'm going to explain to viewers. So Normally, when these applications are refused, either on any of these grounds, which is, for example, these days, because they know that it's difficult to provide proof of address, most times Home Office will allege that the proof of address that one has provided is forged, and they will just refuse the application. Or if one fails to attend an interview for whatever reason, again, even though the guidance says that they should not refuse these applications, they also refuse. So let's look at how the court look at the decision when it's before the judge. First and foremost, if Home Office is alleging that your proof of address is forged, you don't have a legal burden. And I'm taking my time to explain this terminology. It means that you don't have to prove that it is not. The law says that he who alleges must prove. It means that if Home Office is alleging that this document, which is what you are seeking to rely on to show that you were here before December 2020, is forged, then they need to prove that that document is forged, which means that if it's coming from an independent source, then they have to get verification report to show that this is how they verified this document, that they contacted the source brought a report, and that report has confirmed that that document did not come from them. If Home Office is not able to demonstrate that, then it means that they have failed to satisfy the legal burden, and therefore your case should be successful. So you now understand why that gentleman came here to give a testimony, that he came to CITI Law Solicitors, and despite those allegations that he was so frustrated and didn't know what to do, didn't even want to have anything to do with the application, we were able to solve that problem for him. Because you know why? Home Office made these spurious allegations and unsubstantiated allegations that they were not able to prove it in the immigration tribunal. Therefore, our client was to be granted the leave to remain under the settlement scheme. So if you're anybody, any one of you have had some of these decisions, I advise you to talk to your lawyer and don't lose hope, because the legal burden is on the one who is alleging that that document is forged. That's the first point, and that's how the tribunal deals with cases of that nature. The second point is that if Home Office is alleging that your relationship or your marriage is that of convenience, one, because you have failed to attend an interview, again, when the case has gone to the employment tribunal, and the tribunal allows cases to be dealt with either on paper or oral hearing. These days, we mostly do what they call video link. Again, when there is an allegation of marriage of convenience, and in this case, I want to take my time to explain a distinction between two terminologies that are normally used. There is what they call a sham marriage and what they call a genuine marriage. Sham is when people don't know anything about each other. Genuine is when the person wants to gain immigration advantage as the sole purpose. So when those allegations are made, again, when the tribunal is dealing with this case, the initial legal burden, which this simply means that, again, it's just like when one is alleging that there is fraud. The initial burden of alleging that a relationship is that of convenience lies on the Secretary of State. So if the Secretary of State is saying that that relationship is not genuine, then they have the burden. And remember, I've already explained to viewers that the guidance does not allow failure to attend interview as a sole basis for refusing applications. It means that that burden is carried forward to the immigration tribunal, where the Secretary of State is required to show, to prove to the tribunal initial burden that this relationship is that of convenience. If they have not been able to do that, then there is no burden on whoever has made these applications to show that it is not of convenience. This people should also take notice of. So you realize that there are people whose applications have been wrongly refused, and they have been forced to come and prove when in fact there is no obligation of that nature on them, unless and until the Secretary of State have proved the initial burden, which is be able to come out with good reasons why there is that grounds for suspicion or why that relationship is of convenience. Then the burden then shifts on that particular person to prove that it is not of convenience. So tonight, I have been able to explain these topical areas, which is the epicenter, which is where most of these applications are being received, which is an area where Home Office is normally relying upon to refuse most of the applications. So at this point, I am going to open the phone lines. If anyone has a question to ask me, any legal question, I'm going to obviously take my time to explain to viewers. As I said from the beginning, I might not be able to give marriage counseling. I might not be able to give prescription if you are sick, because that is not my job. But what I do know is the law, and that's why I'm here tonight. So I'm going to open the phone lines for you to take the opportunity of this free legal advice to ask any question you so wish. And on Thursday, obviously, MC Chaka will also be here to take us through the tree session of tonight. I have Letitia Aite, who is also with Letitia Aite. Thank you so much for joining us. I have Daniel Awagli. Daniel Awagli is watching. I have Don Volta. Don Volta, who is also watching. Don Volta, thank you so much for joining us tonight. I have Critical Wildlife Flu. Omega is watching. I have Don Volta, who is also watching. I have Sebastian Ugad, who is also watching tonight. Thank all of you for. I have Tina Tamakru. I was meant to send you some information tonight. I'll probably do it for you tomorrow. Thank you so much for always joining this program. I have highly favored Priscilla watching tonight. Raphael Nana Nyakon Owusu, who is also watching. I have Anna Fosua. Anna Fosua, always giving advice for free. God bless you. I feel so flattered. Amen. I have Sophia Ashon, the famous Sophia Ashon, watching. Carol Brown, Dora Fimpong, Teka Opa Edwest, all the way in Nigeria, Desmond in Wallenborough, and Mabel upon Mensa. Thank you all for watching tonight. Tonight, I have already opened the phone lines, and if anyone has a legal question, I do this as part of City Law's duty to fulfill our corporate social responsibility. So at this point, the phone lines are on the screen. I'm going to mention them again. If you have any legal question that falls within my area of practice and competence, I'm going to answer this question for you. It's free legal advice. The phone lines are 0793 293 4518. 0793 293 4518 or 0744 033 8623. 0744 033 8623. So I have these phone lines now open. Now, at this point, I'm going to take my time to also explain other areas of practice that are equally available to you. What I have done tonight is immigration. City Law Solicitors will practice in numerous areas of law. We are here to meet the legal needs of the community. Therefore, we ensure that all those areas that affect people and their legal rights, we ensure that we are able to meet those needs. So City Law Solicitors is like one-stop shop where all your legal needs can be met. We specialize in immigration, which is why I'm here tonight to explain some of these things to people. And I must admit that the settlement scheme initially was quite flexible, and gradually it's becoming quite challenging and difficult, and we are receiving decisions. But I always say that I have been in this business. In fact, we have been practicing for some time now, and I used to say that between 2012 2013, especially those of you who are coming from Ghana, most applications were being refused for the wrong reasons, and we were able to challenge most of those decisions in the tribunal, and most people were granted, and some of you are, to the glory of God, are even naturalized as British. The same phenomena is occurring. When applications are being refused, we are challenging these decisions in the tribunal, and quite rightly so, most of them are being allowed. Somebody phoned on this phone in when I was sitting here for this show, and gave a very touching testimony of how it was alleged that his documents were forged. And when we took it to the tribunal allowed his appeal, and he phoned in here to testify. So people should not lose hope, because when these decisions are made, there's a remedy, which is sometimes to take it to the tribunal, and if judges who are fair-minded will look into the law and make that decision that most times will overturn the decision of the Home Office. We also specialize in employment law, and I always say that if you have been unfairly dismissed, if you are going through discrimination, and you want a lawyer to represent you. We do most of these cases on no fee basis. It means that it's only when the case has been successful that we get paid. If the case is not successful, we don't get paid. But I know that because of the changes that David Cameron brought in, that it's only those who have been employed for more than 2 years who have the right to claim what they call unfair dismissal, which means that if the employer have dismissed you without following due process, then you can claim compensation for the unfairness of that dismissal. But that change that was brought into the Employment Rights Act means that you need to have been employed for more than 2 years. So most people are being dismissed for the wrong reasons, but behind some of these reasons are what you call racial discrimination, disability discrimination. So you have maternity. So you have all kinds of discrimination under the Equality Act. You have some which is bullying and harassment. So all these breaches under the Equality Act are occurring at the workplaces, and people are being dismissed because the employers know that they can't claim unfair dismissal. But I want to assure you that you might not be able to claim unfair dismissal, but you might be able to claim racial discrimination. You might be able to claim that you have been discriminated because of your protected characteristics, such as disability. And I always say that people think that discrimination, when it comes to racial discrimination under Section 9 of the Equality Act, is only to do with white and black. No. The law makes it clear that even those from different ethnic and cultural background can claim discrimination. So you might have somebody who have been unfavorably treated because he's an African, and another person who is an Asian. They are all black, but their cultural background, ethnic backgrounds are different. On nationality grounds, one might be British, the other might be Polish or German. That's nationality, different nationality. So when we say discrimination, I want to always advise you, it is not, especially under race, just about the color of the skin. It applies to the nationality, it applies to ethnic and cultural background. The differences in them could result in treating one person different or favorable from the other, which is called the comparator. So if you have any of these cases at your workplace, the good news is that you can still claim compensation and still continue to remain in employment. Having said this, we also specialize in family law. Under the family law, we deal with non-molestation order, occupation order, child arrangement order, for example, if you want to have contact with your child. For those of you who have been unfortunate that your relationship have failed, we also can assist with your matrimonial law and ensure that you can get the best or maximize the assets that you're entitled to when the relationship breaks down irretrievably and is sadly ended by divorce. We are family law accredited. So we are not just solicitors that will practice in family law. We are accredited, so if we are supporting you in your matrimonial matter, you can always aim for the best, or you can always get the best from us. Personal injury and clinical negligence is one of the areas that where people have suffered accidents at their workplace. Some people are in the car, they get involved in an accident, as passengers, as drivers. We deal with all these cases. If you went for treatment and you had a problem, chronic negligence. And most of these cases, we deal with them on no fee basis. As I said earlier, CITI Law Solicitors is one-stop shop. Your legal needs are all met. Those of you with several litigation issues, somebody is owing you, he doesn't want to pay, we can pursue the person and claim your money for you. So these are the areas that we practice. Those of you whose houses are in a very bad state, very terrible disrepair state, and the landlord has failed to fulfill their obligation under the tenancy, we are here to claim compensation for you. Again, on no fee basis. So these are the areas that CITI Law Solicitors practice. And CITI Law Solicitors is the one that is sponsoring me to come and bring you this, to give you this free legal advice tonight. If you are looking for us, you can find us in Barking. So if you get to the Barking train station, you just turn right, you find a KFC or Santander Bank there, you turn right again, and that road is called Cambridge Road. When you get to number 50 by the traffic light, that is where CITI Law Solicitors is. That is where you will find us. So if you ever have any legal problem and you want competent lawyers to look into it, we are inviting you that our services are available to you. I want to come to the end of the show. I have Herod Osai watching tonight. I have Boama Augustine who have joined us. I have Thomas Asiama. Thomas, how are you? I have Kojo Bobot, Kojo Bobot, who is also watching. I have Din Bajo Mohammed. Din Bajo Mohammed has also joined us. Thank you so much for. I have Azekia Boama, and I think I have already acknowledged Letitia Ayite. So I want to thank all of you for joining us tonight. On Thursday, MC Chaka will be here and we'll be looking at the same topic in Twi. And again, we will take our time to look into it in detail in the Twi language so that our Ghanaian family members and friends can benefit to the fullest, because we'll have all the discussion in the Twi language. Our disclaimer is that everything that has been discussed here is for guidance only. Guidance only. Therefore, if you want proper legal advice and you have a lawyer, you can consult that lawyer on what I have discussed tonight. And if you don't have a lawyer and you want to come to us to assist you as on some of the things that I have discussed here tonight, we are willing to support you. So I want to thank all of you for joining us tonight. God bless you. Thank you. God bless you.